Hi, I'm Marc Cunningham with Grace Property Management. We are in a series of videos where we're looking at the 4 significant changes to law that the Colorado legislature just passed, impacting every real estate investor and every resident in the state of Colorado. So we looked at the bedbug law, we looked at the rental application fairness law, and this month we're going to look at called the time period to cure lease violations. It's House Bill 19-1118. If you're a landlord, this impacts you dramatically because this is a huge change in Colorado state law as far as how long does it take to potentially evict a tenant in the case of non-payment of rent. So here's what it looks like. There are new notice periods, and they're different for multifamily versus single family. So you may have heard the terminology in the past about a 3-day demand notice. And that's been the standard in the state of Colorado. Well, we've been in business since 1978, so at least since then, 3 days notice. Meaning, if the tenant doesn't pay rent and you pass the due date, you would post the tenant with a demand notice, and that demand notice legally, per Colorado state law, gives the tenant 3 more days to pay. It says, hey tenant, you haven't paid, you've got 3 more days, and if you don't pay within those 3 days, then we as a landlord, if we want, we can then begin the legal eviction process with the court. So it doesn't evict them after 3 days, it just starts the legal process after 3 days. Been state law for a long, long time. Well, the legislature thinks that evictions are too high in Colorado. Now, the reality of it is, for our clients, our eviction rate last year was less than 0.5%. We don't evict good tenants. When evictions have to happen, they have to happen. It's because a tenant either hasn't paid their rent or they have major lease violations. So our eviction's a huge problem in Colorado. Nationally speaking, no, we're on the lower scale, but regardless, the legislature wants to see less evictions happening. And so what they're going to do is they're not going to say, we no longer have 3 days. We're going to change that notice period. And here's the way it's going to change. Multifamily is different versus single family. So they say this, the demand notice, and there's 3 types of demand that are most similar that this law applies to. The first type of demand is rent demand. The tenant just doesn't pay rent. So the tenant doesn't pay rent. The legal process is the landlord has to prepare a legal notice and physically post it, serve it to the tenant on the property. And that notice in the past, as I said, would give the tenant 3 more days. No longer. From now on, the notice gives the tenant an additional 10 days, 10 more days. So it doesn't take it from 3 to 5 or to 6, it takes it from 3 to 10. It's a big increase. 3 to 10 days now, they have to make payment that the landlord just kind of has to sit on their hands and wait and give the tenant another 10 days. Now, that's for multifamily. For single family, the legislature changed that to 5 days. So it's not 10 days. If you manage a single family, it's only 5 days. However, the legislature defines single family as owning 5 or fewer units, and you must give a different type of notice. So here's where it gets complicated. So if you're a landlord and you own 5 or more residential single family properties, then you must follow the multifamily rules. And this includes condos or townhomes. So if you have one condo in a multifamily, one condo in a condo complex, you have to follow the multifamily rules. It gets very complex on this. We recommend you just follow the multifamily rules to keep yourself out of trouble. So for multifamily, you need to give a 10-day notice to the tenant to pay rent. This also applies to demand for compliance for non-monetary violations. So let's say, for example, that the police are called out to a property because the tenant has been doing something illegal on the property. Let's pretend the worst case scenario, right? The tenant is dealing drugs out of the property. Well, legally now, you must give the tenant a demand for compliance, and that's going to be a 10-day notice for multifamily. Single family is 5 days again. And the third type of rule is the notice to quit for repeat violations. And that's a legal term, it's a legal process, but in the past, you can give the tenant just a notice that basically says, hey, tenant, you got to move. No more chances. This is your notice to get out, because you've had repeated violations of this. You've been repeatedly notified that selling drugs is illegal out of your property. You still now have to give them a 10-day notice to cure, meaning they can stop anytime that 10 days. This really gives the tenants a lot more legal right to wait, to sit tight. 10 days in the process, if you think about it, that's a long time. That's a third of the month, right? Months are only 30 days. Most landlords in Colorado are not rich, fat cat landlords. They have to make a mortgage payment. And that's one of the beneficial things that Colorado has historically had in place is, look, if the tenant doesn't pay rent, you can get that tenant out if you need to in a reasonable amount of time, typically 30 to 45 days. and find a tenant to come in to pay rent so that you, Mr. Landlord, can make your mortgage payment. No longer. Our attorney says with these changes and some of the other ones that have taken place in court, either way, if the tenant files an answer, which the tenant has the legal right to do so, that's standard law, the trial won't begin until the start of the next month. So this really delays the eviction process in a significant way. Now, how are landlords responding to this? Because this again, this is a big deal, especially for smaller landlords that have to make a mortgage payment. Because if the tenant doesn't pay rent, the landlord can't go to the mortgage company and say, hey, I can't pay my mortgage because the tenant hasn't paid rent. That's not an option. So we're seeing landlords respond in unique ways. We've seen some landlords change their lease to have no more grace period, meaning, typically speaking, the rent's due on the 1st, and it's often commonplace to give the tenants a grace period until the 3rd. So tenant, your rent's due on the 1st. As long as you pay by the 3rd, you're fine. So some landlords are doing away with that grace period to say, hey, your rent's due on the 1st. We're going to serve you the notice on the 2nd if you don't pay, because we want to get the clock ticking on that 10-day notice period as soon as possible. Now, that's a bad deal for tenants. That means late fees are going to be enforced faster. Rather than waiting till the 3rd, landlords may start posting late fees and charging late fees on the 1st. They have to change their lease, but they could do that. We've seen some landlords saying, you know what, we can't accept partial payments anymore. Because in the past, and actually with the current law, the way it works is if you as a landlord take a partial rent payment on what's owed, that kills the eviction process and you have to start over. So if the tenant owes $1,000 and you post them the 10-day demand notice and they come in on day 9 and they hand you $1 and you take that $1 and apply it towards their rent, you have just killed the legal process. Now you have to serve them with another brand new 10-day notice and the clock starts ticking again. Now in the past, when we had a 3-day notice period, we oftentimes worked out payment arrangements with tenants to say, yes, we'll take a partial payment, because if they don't abide by their payment, we only lose 3 days. Well, now we're going to lose 10 days, meaning we're not able to be as flexible on making payment arrangements with tenants. That's why I think this really, at the end of the day, I really sincerely believe this law is not going to help tenants. I think it's going to hurt them, because landlords are going to start charging rent faster, they're going to start charging late fees faster, and they're going to stop making payment arrangements with good tenants. As I said, our eviction rate last year was less than 0.5%. I don't know if it'll be that good this year. Why? Because we have to respect the rights of our landlords. So we can't take partial payments, meaning tenants are going to potentially incur legal fees sooner. It's just not a good rule. Well-intentioned law, but I think the results of this will not be real positive for tenants or for landlords in Colorado, but I could be wrong. We'll see how this plays out. If you've got questions, contact our office. It's a complex law. Grace Property Management. We're not attorneys, but we're working with our attorney to ensure that we're in full compliance with these and we keep you as a landlord in full compliance on these new laws.